do with the idea that Party Article 7 somehow applied only to attorneys in the House. And the historian, in fact, presented that as a conclusion. Unfortunately, he had not read, as it turns out, the last bit of research that Mr. Lambert had prepared for us, which was the adoption of the House Rule 1793, which the House representative being fully explanatory of the constitutional amendment, which said, in fact, that the prohibition on taking fees, for actions in the House was universal, applied to anybody, whether they're Republican, well, there you go, Republican, Democrat, whether they were it applied to anybody, whether or not they were a lawyer or a legislator who was not a lawyer. So the rule was a universal application. Basically, the nexus was, if you were to read the 93 rule, is that if a person was paid to act on behalf of another, or if a certain amounts was paid to act on behalf of another, they would forfeit their seat. That's the short version. Now, there is still, obviously, a body of opinion out there that would like to narrow that definition. And so, I'm sure many of us are struggling with some of this. In any event, at last session, in order to try to understand what that might mean in a contemporary way, it was suggested that we look into more or less contemporary practice to see whether or not that concept had been violated in recent years. And what the thought was we would go back 20 years and we would look at the history of service in the House and take a look at individuals who perhaps worked for corporations, worked for political parties, or whatever. Where any individual in the House who may be paid by a third party who may have been entering legislation and promoting activity before. In the interest of sort of understanding or seeing whether or not there's a different conception today than might have existed back in 1793. Incidentally, for those new people here, that rule was on the books only for a period of about 6 years. There are no other constitutional provisions in House rules, so it may have just been perhaps that once they established it in practice, they figured it was redundant. But that's for someone else. That's my speculation. But so anyway, so we thought we'd look at contemporary practice. Now that's turned out to be a lot harder chore than we may have imagined. And I don't think I realized how difficult a chore it was until I talked to Mr. Lambert on Tuesday this week. When you start to think about it, 20 years of legislatures, and we replace, on average, and not to say that this is the number, it's just a speculative number, we replace on average a third of the House every 2 years. That's like 120 members. I mean, it's a lot of representatives. And if you multiply that out over the same time frame, over 10 elections, that's 1,200 members, plus the members in the first. So you're up around 1,600 members. You sort of start to say, well, it's like looking for a needle in a haystack. That's an awful lot of people. And it suddenly appeared to be a tremendous burden to try to begin that and try to do it in any kind of timely way to see whether or not the conception of Rule 1792 was being violated today. So I'm just informed the committee that we're sort of at an impasse here. We could continue in this direction, or perhaps we might do something else. The thing that I've been thinking about is this. There's been some complaint that we haven't got to these hearings right on. Initially, when this process started, the complaint was that the advocates for Mr. Brunelle wouldn't have enough time to respond if we started something early, so they wanted a period of time to prepare. So, you're damned if you do, if you're damned if you don't. Now there are complaints that we're not moving fast enough. My thought was, at this point, that we take the materials that we put together that represent the best efforts of our research people, particularly Mr. Lamb, who's done the bulk of the work, practically all the work, is we take that material and we submit it to to the House Counsel and ask for recommendations what we should do. I've never conducted hearings that involved that were more of a quasi-judicial nature. To tell you the truth, I would be out to sea without some guidance on that myself. Because I would assume that if you were going to do a proper job and allow Representative Brunelle to present fully his case, you want to make sure it would be done in a formal and fair way. I've never done that. I want some guidelines. I want to know how to do it, if that's where this is going to go. A council may look at this material, House Counsel may look at this material and give us another opinion. I don't know. But the materials that we've put together today, just again for the benefit of new people here, all of our committee members have received this. I believe that that material is made available to those individuals who are representing Mr. Brunelle. So this is all public information. But what it includes, for the benefit of those new people here, a research brief, New Hampshire Constitution Part 2, Article 7, with attachments, which I believe, excuse me, and then excerpts from the House and Senate journals from 1790 to 1791. It includes excerpts from the Journal of the Constitutional Convention of 1791, where Part 2, Article 7 was discussed and obviously adopted and proposed as an amendment. The proposed amendments themselves from 1791 to 1792 of that Constitutional Convention. Memorandum to me from Representative Lambert having to do with the New Hampshire General Court authority to expel a member, which was dated January 7th, 2011. I think that's the place where the case, the Snow case, was reported to us. That was a case of a member who was in the early part of the 19th century. Then we also have copies of Chapter 2 and 3 from William Plummer of New Hampshire by Lynn Turner, noted historian. We'll include an index of all of petitions that were filed before the General Court between 1787 and 1795. And as I explained last time, the reason for looking at those petitions, before the date of Part 2, Article 7 adoption and afterwards, is to see whether there's any change whatsoever in the way that the legislature worked or the way petitions were filed. And it appeared to me anyway that there was really no practical difference whatsoever. And then we have excerpts from the New Hampshire State Constitution by Susan Marshall. We have a research brief, which New Hampshire Constitution Part 1, Articles 31 and 32 of attachments. Another memorandum to me, New Hampshire Constitution Part 2, Article 7, dated February 16th. By the way, the February 16th memorandum is the one which included or revealed the House rule that was adopted in 1792. And then we looked at the next question after that, as I explained last time, was we want to know how long that rule was in effect. The next piece, the memorandum to me, had to do with 1792 to 1806 House rules dated February 23rd to 11, which you have. And then there was a packet having to do with Legislative Ethics Committee and the lobbyists, because, as I said, the reasons why we looked at those two things, the legislative ethics rules and the lobbying rules, is because the question has come up, or came up in the course of this, as to how any of this would apply to either one of those issues. So, as I said a minute ago, I'm sort of a mind that I would like to get the opinion of House Counsel as to where we go from here, because I am at sea on the process, and I think it would be helpful to have an opinion. Yes, Reverend.
Good question, sir. What's the House Counsel? Is it a lawyer for the House?
Yes.
Or is it a council of people who are going to take this up?
No, it's a lawyer for the House.
The lawyer for the House, thank you.
Yeah. That's our Reverend.
I have the question. I'm under the impression that it's the duty of this committee to take the information in and reach our own conclusion about it. I don't think it's the duty of this committee to take information in and then hand it off to a third party to tell us what we should think about that information. I think we've all got stacks of hundreds of pieces of paper that we should be able to reach our own decision about. I don't think handing it off to the House Counsel to tell us what we should think is the appropriate action.
it seems to me as though, in the context of our discussions, we have not been able to come up with any kind of definitive type evidence, nor with a process perhaps that is akin to a trial, where we can actually gather
That's right.
evidence. We have got a huge amount of historical content, which I think is, at least from my perspective, is pretty useful. But perhaps the way to go here is for us as a committee, following Representative Brown's point, to say, let's put a stop to this particular part going after, if you will, Representative Brunelle. But let's also maybe perhaps send to the House Counsel what we've come up with so that we can maybe adopt a rule that better reflects what we're trying to do down the road. And I think that way the institution is very important to me, process is important to me. And I think what we're doing is damaging the boat. And if you would like, I would make a motion, something to that effect.
I'd like to hold the motion until we have a chance to have some discussion, but I think, I'm not necessarily opposed to that. Representative Duarte and then Representative Wallner.
I think a lot of our discussion keeps going back to what's been going on over the past several years. I think what we should be concerned about is what's going on now. And I wasn't here 5 or 10 or 15 years ago. This is my first year here. But the problem I have right now is we're dealing with a case, and if you read the statute, we have a violation here. That's my opinion. So for us to kind of just shift it aside, I think we'd be remiss in our duties. I think we have to discuss some way whether this procedure is going to continue, or we're going to stop it right now. And what are we going to do from there is, I think, where I would prefer some legal counsel as to what the result, because this is very cut and dry.
Well, I'd like to respond to that. We have not taken the next step that would allow us, I think, to come to that. In other words, I think for the committee to come to that conclusion, you would have had to, we would have to take the next step and ask for employment records and look into all of that. And that means you move into inquiry, into a much more aggressive inquiry. And I'm sort of in a timeout mode myself, somewhat, I mean, it happens to do something with Representative Kidder's thoughts, because I think the next step is so serious. And once you get to that point, then you would determine whether or not there is a violation. What may appear to be the case, someone may just make it, that process may conclude is not the case. I don't, we all each might have our own opinion about that, but I don't want to suggest that that's the position of the committee right now. I don't think the committee's had a chance to come to any decision. I think Representative Wallner had a point, and then Representative Johnson.
Well, I mean, I've been sitting here for the last several weeks and we've been hearing from historians, we've been hearing from the Ethics Committee, we heard from the Secretary of State's office. I have not seen anything that makes me think that we have a representative who is in violation here. I think it's time to move on. Send this back to the floor, that we find no evidence that there is a violation here. And I've been really concerned. I have been here for a long time, and I'm really concerned that we have a process that went into place about 20 years ago. We've heard about it, the Ethics Committee. For some reason, we have chosen instead to try to find another way of dealing with something that came up on the floor on the first day that we were in session. And it has felt to me like it was just some sort of a witch hunt from the beginning, and that it wasn't really really a true, it wasn't really there because people really believed there was a problem, but it was more of some sort of a stunt, really. And I'm concerned, and I think I'm concerned about the house, I'm concerned about this institution when we act that way. And, I think that we need to get past this, we need to, move it out of this committee, get it to the floor, and put it behind us.
I would say that this is certainly not a stunt. And the reason for the delay is to do it is to make sure you understand what the charge is in relation to the constitutional language. That's the first part of the charge we were given. I can read that to you if you wish from the speaker. The charge the committee was given essentially said, pursuant to a motion passed by the House this morning, House Rule 4.1, hereby refers to the Legislative Administration Committee the following question: whether there has been a violation of Part 2, Article 7 by Representative Michael Brunelle, and that Representative Brunelle is alleged to have filed legislation directly arising out of his duties as the paid executive director of the New Hampshire Democratic Party, and it's further alleged that he may have taken fees and payments relative to causes before the New Hampshire House. To get to the two-thirds of this, you've got to find out what Part 2, Article 7 means. And really, that's been what's been going on for the last several weeks. Now, whether we take the next, we have a charge to take the next step. So, what I'm saying is, before we take the next step, I'm sort of in a, as I said, sort of personally, I'm in sort of a timeout mood. Timeout mood, yeah, that's probably the wrong word. Before we take the next step, I would like to make certain that there's some, we understand, we have a sense that the materials we have produced would validate, would justify doing that. And so that's why I suggested that this material go to the House Counsel, that the House Counsel provide some recommendation to the committee, and then the committee can take that report up and decide whatever it wants to do with it. But at least you'd have an opportunity to have that opinion before you, and then we decide. If we want to do as Representative Brown says, or something as Representative Brown would propose, or Representative Kidder would propose, we would do it after we've had that, after we've received that recommendation or report. Yes, Representative Johnson.
Yes, thank you very much, Representative Mirski and Chair. I'm listening over here and I'm trying to hear the various pieces, and I have to say one piece of me that says what's going on for me is there's a lot of emotion in this room. And then besides that, there is this issue that causes a lot of people concerns, not so much in relationship to this individual, but rather, as my colleague said, from here on. And if in fact we could separate the two, you know, put this to rest, get the emotion out of it, get the person out of it, and then we could take a look at what we ought to do in a future setting. How do we find out all that information? How do we do this correctly? So that's the one piece that's sitting over here with me. The other piece, as a member of your committee, and yes, I agree, I've just been here for this year, but I think that if we forward this, after all this work and all the information that the historian has brought to us, which was very interesting, I think it invalidates the committee's thinking. I truly believe that we have all given it our best. This isn't something that we have just sort of whimsically discussed. And so my recommendation would be not to let it continue. I think, or to pass it on, I think we're just passing a buck. And I just soon keep the buck. So that's what I'm thinking. Thank you
I'd
for
say
listening.
if you're going to keep the buck, then you sort of have to finish the charge, which is move to hearings. So that's, and where we're at is I think we're at a transitional moment. If we were to take that step, I'm just arguing to take a pause and look at it, to see what that actually entails. Because we haven't completed the rest of this charge.
In all due respect, in your thinking, is that?
Well, I mean, I just read what the charge is. We we haven't looked at his duties, we haven't looked at any of that. We haven't.
Sure.
Right? And so, if you're gonna step out and actually do that, that requires a lot more activity from this committee. And it also requires a process that's fair to the parties, fair to Brunelle, and Representative Brunelle, and that's why I'm arguing for this time out, and some advice, give us some advice. Yes, Representative.
Thank you, sir. I am one who has been following discussions on the national and the state level about two different interpretations of our Constitution, both in the national scene and local scene. Justice Souter spoke at Harvard a year or so ago, and I went back and dug out what he was saying, because he was talking about two ways of reading the Constitution. One he called an originalist, and what he meant by that was the people who look at the Constitution, and read it as a literal interpretation with no chance to change it. Whatever it says, and we don't interpret it except exactly what we think it means. The other side is the people who determine it as a legal document, that a living document, if you will, that changes according to the needs of the people who are living with the document in this day and age. So as I read that stack of stuff, which I must say I read about 85% of it, I read it through this lens of originalist versus living document. And as I read it and asked about the originalist of the petitions, we've all read the, what was it, 185 of them, it seems like, from the 1790s, about people coming to the general court who had lost a case or did not like the outcome of a case, and they came here for, well, basically, I guess, redress of grievances. And people who were in the House, because they had this dual role at that time, were able to take these cases for money and bring them, and hopefully get the outcome changed. There is no indication anywhere that Representative Brunelle has ever brought a petition to the General Court of the state of New Hampshire to try and get a different court system overturned. It just has never happened. So when I looked at a lot of this, I looked at the originalist. Then I looked at from the living document perspective. Well, it was in the 1800s sometimes, and I'm sorry I don't have the exact date, but they changed the rules of the court. That's when they separated the general court from the court system from the legislature, so that legislators would legislate and judges would judge. So they took this out of the Constitution in 1800. So if you look at it as a living document, it doesn't apply now either. That's the way I have been looking at everything, and I throw my thoughts out for the rest of the committee to accept or reject, but to me, that's what it looks like.
The only thing I would say in response to that is petitions have been entered into the House as late as this century. Early, in fact, I think there's some reference in here to very late petitions. So the practice of that went on, but it also is what the House rule says. It doesn't necessarily refer to petitions. What it says is, the 1792 rule said this. The committee to prepare rule, and I have the actual handwriting here if you want, to be observed by this House, explanatory of a clause in the Constitution respecting members taking fees, meet of council, etc. Reported the following as fully explanatory of said clause. So the House and the participants, the individuals who crafted this constitutional amendment, are now saying that this House rule is fully explanatory of the clause, that is part 2-7, that no member of this House shall either directly or indirectly take any fee or reward for bringing forward or supporting any petition or motion, not just simply petition, or motion before before the legislature, or either branch of the same, a committee thereof, and by has received the same, or accepting any promise of compensation, therefore shall flow to the city's house. So they're going, it really refers, it goes beyond petition, it says any motion, any action that you could potentially be paid for. We haven't talked about whether or not President Brunelle has been in a position, because as I said earlier, we haven't stepped to the next, we haven't taken the next step. But I think to suggest, I think that the intent, at least, again, from my point of view, in terms of the rule with respect to behavior in the House, is fairly clear to me. There's a disagreement, I'm sure, certainly here, within the committee perhaps, but that's what the rule says. And the interesting thing about it, what caused me to ask Representative Lambert, I keep wanting to get him into the legislature, Mr. Lambert, to look further was, the question I asked him, I said, well, if that's not the meaning, then why did the practice stop altogether? And the practice stopped altogether following that. It was never, and there's no evidence to be remote after that. So that's one thing. Yes, Representative.
Thank you, Mr. Chairman. I want to echo everything that Representative Chase has said. And are you, I was going to say one thing, then you said something else that maybe, you said that once this constitutional provision was passed, this practice stopped altogether?
The practice of third parties paying individuals in the legislature appears to have stopped altogether.
Well, I disagree. I've heard evidence says otherwise. I'm going to have to try to find a piece of paper that says that.
Okay.
But I will point out to you that this clause was passed in 1792, and this list of petitions that you were given to me dates to at least 1795.
Oh yes, it goes beyond part.
And when you look at the type of petitions that are listed here, it was ISM to request payment for distributed and returning election precepts from the Secretary of State. Jeremy Liddy asked permission for minor mark signs to sell land in Portsmouth. Jeremiah Eames asked Randall Islands of Connecticut River.
Sure.
These are clearly petitions brought on behalf of an individual.
But not for pay.
Well, I'm going to try to find a piece of paper where I believe even William Plummer, who was behind it, doesn't believe that that process stopped after the passage of that constitutional provision. I'm sorry, but as a number of people have said, that's the paper that I, of course, I don't have the one I'm looking for in front of me, so I will look at that while other people go on. But I really do believe that when the term cause in this Constitution refers to people seeking a judicial resolution in the legislature. It refers to people trying to get trials overturned. So it may not have applied only to attorneys, but was definitely aimed at attorneys who lost cases, who couldn't get the results they wanted through the court system, and went running to the legislature and said, oh, can't you pass a law to fix that court case that I didn't win?
And what we heard from the historian was that the petitions for pay wasn't defined necessarily with lawyers. It was a common practice.
I agree. I think at that point in time,
So-
we get a lawyer.
So what I'm getting at is we don't have, following the adoption of this House rule, the practice of being paid by a third party to act on behalf of that third party in the legislature appears to have ceased. Now, it certainly has not been practiced in the House today, otherwise we would very likely, a lot of us would be earning a lot more than $100 a year because we represent interest groups from outside that could easily pay their bills that would satisfy their interests. So we don't see that as a practical matter. And so that's why I said what I said. Anyway, yes, Representative Johnson.
Thank you. Again, I appreciate the opportunity to speak. We had a lengthy debate last week about what kind of quote-unquote proof would we have that this individual has done something improper. We know that he works, his job, what he supports his family, is as an executive director of the Democratic Party. We know that. But we each, as I remember Representative Brown saying, if we could get a job which really reflects our beliefs, we would go for it. And in this case, I have not heard any kind of information that says, oh, this is where he actually took X number of dollars paid by so-and-so and so-and-so to bring a bill before the House. And that's what's troubling me. I don't really see that. I hear conversation about this this part of the Constitution, and I really value that. Certainly furthered my education. But I don't want anything that says this is what this individual did. And we're gonna prove that he has not obeyed the Constitution. Thank you.
No, I'm not actually proving any of it. I mean, the whole point of the hearing is to determine whether or not it happened, whether or not that's the case.
It seems like the hearing doesn't have all the information, that's what.
Well, we have to, again, we have to take this next step. We have to move into a next step where we seek that information. And again, that brings me right back to the beginning. We're gonna take the next step. And it seems to me worthwhile knowing how to take the next step. And understanding that we would have grounds to proceed, to take that next step. And, I would like some input on that, quite frankly. Yes, President Ball.
Thank you, Mr. Chairman. And listening to, everybody's made some very good arguments in my estimation. I think we all lay the cards right on the table. Representative Brunelle is not your run-of-the-mill representative. Okay? If he were a dairy farmer from West Lebanon who was here arguing about whether we should vote on farm subsidies for dairy farmers, if he owned a windmill factory arguing whether we should participate in Reggie or something like that, we'd be able to say he has a financial stake in that issue and that's why he's arguing about it. If I came in here, as we talked about last week, and argued about a particular land sale by the state that I happen to be involved in as a real estate broker, you'd be able to see that I had a financial stake in it. The fact of the matter is, he's a Democrat, and we have Democrats and Republicans in the House, and this is a political issue. We're gonna put that right on the table so everybody can see it. This is a political issue. If he were someone else other than what he does for a living, this would already have been resolved. The fact of the matter is, what does an executive director of a political party do? What do his employers expect him to perform in order so they can say whether he's successful at it or if he's not successful at it? I would say that he is charged with, I don't know this, I've never been an executive director of a political party, I would say he's charged with carrying out the party platform, making sure that becomes a reality. I have a job review at my job, I imagine he does too, and they bring him in and they say, well, Mike, you did a good job this year, we're gonna keep you on for next year. Or you did a horrible job, we're gonna get somebody else. What does that look like? We need to understand, what does he get paid to do? And is that a bad mixture with his role as a state representative? And I think he deserves the fair opportunity to answer that. There may be a very good example that he can give us that I get paid to do X, Y, and Z, and it has nothing to do with what I'm doing in the State House. That's what this issue's about. If he was a dairy farmer, I think we'd already discovered the rationale and the conclusion of this. And I think really we've got to find out, what does it mean to be an executive director? What are your duties? How do they measure whether you're successful at them? And are they related to what he's doing on the floor of the House? And I think to pretend that this is not a political issue, we're kidding ourselves. Nobody believes that. We all know that. He's a Democrat. Some of us are Democrats, some of us are Republicans. That's why we're even talking about this issue. We need to find out what he does. He was a political director prior to being elected, as I understand it. What did he do then? And has that changed now that he's also a representative? I think those are fair questions. I don't think that's a witch hunt, with all due respect. And I think until we find those out, find out the answers to those questions, we're gonna be in here for 1,000 years. That's all I got to say about that.
I believe that Representative Ball, Representative Duarte, and Representative Johnson are right on the money. I believe we need to take that next step and ask these questions. I don't think it's fair that the committee would consider just walking away from it and said, nothing to see here, move along. The accusation was made on the floor of the House, which in itself is a serious consideration. All of the membership there heard it, or those present that day. This committee was directed by the Speaker to perform a function that you've read to us on a couple of occasions. I believe we need to take the next step. That's the only way we get to the end of this, is to ask those next questions in a, what's the form? the next set of hearings, that's it. Without moving to hearings, we'll be discussing history again. And I believe we've discussed history long enough. I believe we should just take the steps that are available to us and move forward.
To take the step, they still require some kind of advice on the procedure. So I would be in favor of, myself, President Kidder, if we would accept, then he would make that motion. To allow us to take this to the council, tell us what we should do from here on out. I don't know.
I don't wanna make that.
You don't wanna make that motion. What motion do you want to make?
I wanna end the discussion about Representative Brunelle and then move forward so that we establish a continuity between the Constitution and the rules going forward, so we don't find ourselves in this situation again.
President Brown.
Thank you. Thank you, Mr. Chairman. I want to respond to what Representative Ball said and Representative Congress said. I want to echo what I said last time we had one of these meetings where I said, using the state's legislative inquiry power, its power to investigate, to start poking holes in a political organization, to find out how they run things, to find out how their executive director does things, is an extremely slippery slope that I think we have to be very carefully treading on. And I think I could not agree with anything Representative Ball said more than that this is a political question, and some people are trying to use this legislature's governance power, its investigatory power, to go after, try to score political points against somebody. And I'm not accusing anyone on this committee of doing so, but I think when people start saying things like, well, how does the Democratic Party run things? And we're gonna use our power as the legislature to find out exactly how the Democratic Party run things. I would submit to the Republican members that if somebody said 2 years ago when the Democrats were in power, we're gonna use the legislative committee to investigate how the Republican Party operates their business, you'd probably be a little worried about that. I think that's a fair statement for you to make, and I just wanted to repeat that here, that if we wanna go forward and investigate like Brunelle, let's investigate it, but let's be careful that we don't suddenly turn this into, well, why don't we just find out everything about the state's Democratic Party so we know exactly how we run things, so we can make a determination.
Yes, Representative Duarte and then Representative.
Yeah, I want to mention that, you know, it would be a lot easier for us just to move on, but I have a couple of concerns. One, if the young man is innocent, we need to pursue this thing and let's declare such or have counsel come in and assist us with it. And the other problem and concern I have is we need to make a determination of what's gonna happen 2 or 3 years down the road from now. I would like to be able to say, this is really clear now, I understand that, because there's a lot of ambiguities here. I think we all understand Article 7, but I think what we don't understand is who's guilty. Is he guilty of this thing? He may not be, but we don't have enough facts here, I don't, to justify that. I don't know what bills he's put in, what bills he's supported, but I agree, it's a lot easier to kind of close it right now and move on. However, as political as this is, and we have Republicans and Democrats, I don't feel I'm trying to act in any way like this. I'm just trying to do the job that they put us in here to accomplish. One would be make a determination for this young man, and let's get it clear behind him, and put it behind him, and let him continue to do what he's been doing if it's okay. On the other hand, when this comes up again, there'll be no question about it. You know, we'll have a cut and dry case and that's it. That's my opinion.
The sentiment is, it would be nice to have some language that would prevent this to come back in the future. I'd certainly agree with that. President Ball.
Thank you, Mr. Chairman. And in reference to the comments by Representative Brown about, you know, had we backed up a couple of years ago and the Democratic Party was in charge and done something similar to if the roles were reversed, I wish that would have happened, because we were in very good shape a couple of years ago, so probably could have used certainly the review. But the issue here, as Representative Duarte said, we need to find out going forward what's going to be the standard also. But I think at the core of this, for me, and this is what I keep coming back to, what is permissible for a representative of the New Hampshire General Court to be engaged in as an employment? We would not probably allow somebody with an orange badge to also be elected as a state representative, if they are a lobbyist. And we need to find out, because I'll tell you what, if anything goes, there's gonna be a foot race across the street here, as everybody sign up to be a lobbyist and get paid, and we can just come here every day and make a nice salary and hang out at the State House. I mean, everybody, as a volunteer legislature is basically what we are. There's 400 different careers. Some people are retired, some people are independently wealthy, some people work 8-hour jobs every day. So we're never going to get away from that fact of reality in New Hampshire. We don't pay our legislators $100,000 a year like they do in California, so that we're all professional politicians. And, you know, I keep coming back also, Representative Brunelle he's had a very serious allegation leveled against him, leveled against his good name, and this is not about digging into the inner workings of a political party. You know, I think I understand the Democratic Party, I think I understand the Republican Party. I don't need to know their inner workings, and I mean, they publish it on a website. Their party platform is on a website. Anybody in America can look at it, okay? But the idea that, of where we draw the line as far as what your profession is and what you do, his actual profession is as a political director. And what does that mean? And this could be cleared up in 5 minutes. If we have a chance to ask him a couple questions, he answers them, we're done. Or we can drag this out and dance around it and never get to the meat and potatoes of this issue, or we can make this last for the entire session if we want. And if we really want to get this thing resolved, there's an easy way to resolve it, and that is to resolve it. Or we can keep on dragging this thing out and beating a dead horse.
Going back to what Representative Chair said about separating Representative Brunelle from these proceedings and determine what we're allowed to do and not to do, words to that effect. I don't see how we could disengage Representative Brunelle from these proceedings. That's why we're here. There was an accusation made against him. We need to proceed with the work of the committee. We're charged with determining, did he do something wrong? We need to answer that question. That's the only reason we're here. We're not here to rewrite the legislation. We're not here to change the charter. We're not here to change history. We're here to answer the question that was given to us. Did Representative Brunelle do something wrong? So I don't see how we would separate him from these proceedings.
Thank you, Mr. Chairman. I've read some of your historical preparation there, but recognizing I'm Johnny come lately, I'm kind of curious as to why the committee didn't start, and maybe did, but I didn't see it in any minutes, that start with looking at the legislation that was proposed by Mr. Brunelle and seeing if it's unique to his employer. That seems to me the way you tell whether he's getting paid to present this stuff, and it seems really simple to do it that way. I mean, is there something unique about, I think he had a bill on the Navy Act, is there something unique about that that would be responsive to the Democratic Party as opposed to being something that is important to the whole state of New Hampshire? I mean, he doesn't lose his First Amendment views or rights just because he's his employer. So I would have thought, you know, you could start with his legislation and see if it's unique to his employer.
Well, I can answer for myself. You're gonna measure against some standard, right? And we don't even, the question right off the bat was, what was the meaning of Part 2 sub? That was the very first question that was asked. So, if you don't know what you're dealing with, if you're not absolutely clear in terms of what you're dealing with respect to Part 2 sub, and there's certainly a difference of opinion as to what it means. First, the job, it seemed to me, would be determined to get some kind of closure on that, and then to take the next step to see whether or not, when you ask the question as to whether it's unique to his position or not, you would then judge that act in the context of whether it's a reflection, whether his job required him to do that. In other words, there's a direct connection, monetary connection, between what he's doing in the House and his charge he has a good opinion. So, that's why we started off the way we started off, rather than get into the deep into it right off the bat, without understanding what the originating idea was. It seemed inappropriate. So we're now at that point when we sort of fish or cut bait. I'd like to make one, Representative Brown, you want to make a comment, and I have something on it.
Well, the comment I wanted to make was, thank you, Mr. Chairman, was something Representative Ball said about, do we want someone with an orange badge running around as a legislator? And it just boggles my mind that somebody is a lobbyist, they have an orange badge, they decide, I want to be in the State House. And they file their papers to run, and they go door to door, and they shake hands, and they put up signs, and they write editorials in the paper, and then they get elected, and they win. And now he's gonna walk to the State House doors, and you're gonna say, sorry, you're a lobbyist, we're gonna kick you out, and go back to the state and go back to these voters and say, sorry, he's a lobbyist, he can't represent you. And they go, well, we know he's a lobbyist, we voted for him. I mean, we really wanna be picky and choosy and say, or to reach a point where we have to figure out what kind of job a person holds, that they can go get the votes of people in their district?
I would only respond by saying, you just described the legislature prior to 1792. I mean, that's what you just described.
I'm talking about-
You described individuals serving were driven by monetary interest on behalf of clients. That's exactly what you just described.
I'm just baffled by the notion that maybe I work for the Sierra Club and I live in a town that really likes the environment, so they decide to elect me because I work for the Sierra Club. And you say, oh no, you're a lobbyist for the Sierra Club, you can't get in. And it was, well, part of the reason we voted for him was because he was working for the Sierra Club. It just boggles my mind that we as a legislature would suddenly decide that we can determine better than the people who elected them who should represent them, and we should disenfranchise voters because we don't like the jobs of the people who elected them.
Thank you, Mr. Chairman. Representative Brown, the issue you used to illustrate, if someone were to be a lobbyist, when they came in, they're lobbying for a specific industry or specific whatever that is. When bills came up pertaining to that, they would have an opportunity to abstain from voting on that. And I'll use myself as an example. Right now, we've got a commuter rail bill that's going to be coming through the House. Now, my company is going to sell the land that the commuter rail station in Nashua sits on. If it passes, I'm going to get paid. But I don't believe in commuter rail, and I'm going to vote against it. Or I'm going to abstain from voting. Now, I'm taking money out of my pocket. I'm telling you right now. I'm going to take money out of my pocket. It'd be the easiest thing in the world for me to not say anything and argue for it. Because I am going to receive a check if that piece of land gets sold. Now, that piece of land is going to get sold anyway. But I get a bigger check if there's a commuter rail station on it. But I also happen to not believe that we ought to spend money on commuter rail. So, I'm going to recuse myself from that discussion, and I'm going to abstain from voting. I think that's the right thing to do, because I have a direct financial interest in the outcome of that legislation. Now, I use myself as the example. Mr. Brunelle represents not a specific issue, but an ideology. And that's what we're talking about. What does it mean to try to put a party platform and all the spectrum of all those things? What does that mean when he is charged with making that a reality? It could be putting a bill for the shipyard, it could be a minimum wage bill, it could be benefits for the teachers union, it could be a million different things. That's why we need to ask the question. This is not a witch hunt. We're trying to find out, what does the guy do for a living, and does it impact his service as a representative? Are the people who elected him, as you said, he ran in Manchester Ward 3, I'm in Manchester Ward 9, or Ward 2, Hillsborough 9. He's in the inner city Manchester Ward. He's a fellow Manchester representative. Those people, they know what he does for a living. He knocked on the doors, he sent out mailers, and they voted for him. They have an opportunity to be represented in the State House. But, as someone who was a lobbyist, would we then tell those people, you voted for a lobbyist, but your guy can't be a part of legislation that pertains to the people who pay his daily wages? And that's what this is all about. It's not about dragging Mike Brunelle out in the street and kicking him down the street. It's not about attacking the Democratic Party. It's about what are representatives allowed to do and what are they not allowed to do. We don't want there to be 400 lobbyists in the State House, do we? Because that's what would be the logical conclusion here. If there's no rules about how you get paid and who can pay you, then we are going to have paid lobbyists as state representatives. That is a possibility. Everybody does something for a living. My boss told me I had to make something happen as a condition of my employment. Then I'm a lobbyist for my boss, or for my company, or for my industry. And that's all this is about. This is not a witch hunt against the Democratic Party or Representative Brunelle, in my opinion. And this is an opportunity for him to come out and clear this up, and we can ask some questions and get some answers, and that's it.
Representative Duarte and then Representative Chase.
I think, when we did run for the legislator, there are rules. A legislative employee code of conduct is very explicit. When it is listed under prohibited activities, and it says a legislative employee or officer shall not accept any employment to serve in any position in addition to the legislative employment which would impair the employee or officer's independence of judgment. So I think when we do run, I think you could run into some conflicts, but that's pretty clear. It tells you this is the way you should do it, and if you're working as a lobbyist, by reading that, you would say, gee, that's not going to work too well. So one or the other. The other deal we come up with from time to time is that I've been in situations where you have to vote on something where you've got to recuse yourself. You just know it isn't right, and Representative Hall brought that up. So that's another issue. If somebody puts some legislation in that's going to affect him one way or the other, he can certainly step down. And I think there's a section in that deals with that, and they do ask you recuse yourself and so on. And that's another area. If he did take himself out of the picture on any of those cases, that would make the young man innocent. So that's an issue we have to address down the road. But it's pretty clear on the code of ethics.
Okay. Let's see, I have two more and then we're gonna have a brief recess. Yes, Representative Chase.
I'm interested in what Representative Ball said. Thank you for pointing this out. I know that as a citizen legislature, most of the people in the legislature have to earn a living somewhere. And ideally, one earns a living in something one believes in. We kicked this around a week ago, you and I, about can I put in a bill that would benefit children in education because I'm an educator. And with a citizens legislature, it seems to me, and this is just my opinion, but it seems to me that if people were disqualified from serving in the legislature because they have a vested interest in education or the environment or whatever, we might have trouble finding 400 people who don't have any interest in anything else except serving in the legislature. Just an observation.
Let's see, what do I have here? Representative Wallen, right?
I think you've had a lot of questions here about whether you can be a lobbyist and a legislator or all these things. And Mr. Lambert is sitting in here, and he actually is the person who's done a lot of the research on that and really understands probably the ethics committee and their duties better than anyone here. I wonder if we might be able to get some of that cleared up with Mr. Lambert.
Care to address the ethics issues?
Well, yes, the provision that Representative Duarte quoted is actually for legislative staff, not for legislators. But
Who's it for?
staff, such as myself,
Oh.
the legislative employees, it's a separate section of the guidelines, section 6. If there is a section that would apply to what you're discussing, it would be prohibited activities, which is section 4, paragraph 1, subparagraph F, which I gave a copy of this to the chairman.
Okay, do you have that, Andy?
You would read it, or?
Yes, please. No, you can read it, you don't have to pass it on.
Oh,
I'm all for it, pass it down. Okay, 4, prohibited activities. Legislators shall not solicit, accept, or agree to accept anything of value from another for themselves or other persons if the legislature receives such thing of value. In return for having given a decision, opinion, recommendation, nomination, vote, or other activity, this is difficult to read. Definitions of official activities would be as follows. Official activities is the conduct of activities which relate to official responsibilities, including the introduction of legislation, testifying before any legislative committee or state agency, voting in committee or in House or Senate session, or otherwise participating in, influencing, or attempting to influence any decision of the legislature, county delegation, or any state agency. So you can't do that except anything of value, which would be a rate, or a gift, or anything of that nature. Right? So if you have a direct financial interest, a subject that you, in what you, the subject matter, you're prohibited from doing it.
Unless you file a conflict of interest there, right?
Well,
Because we certainly know a lot of bankers that vote on banking issues, and a lot of real estate agents that vote on real estate issues, and we can go right down the list.
we have disclosure forms, that's correct. That doesn't mean, what happens with the disclosure form, though, is you could file a disclosure form, and still, you may reveal you have a conflict. But if there are conflicts that can rise to the level where you do fall under restrictions, if you can wind up being censured, or perhaps even, well, we'd have to look, Rich would be able to speak to some of those charges. I wouldn't want to speak to the legislature. Why don't you want to care to explain some of that, how that works?
Well, you're required to make disclosures of financial interests, but it seems as though that perhaps this provision you just read captures pretty much what Part 2, Article 7 was all about. Because here it talks about directly being compensated for doing something,
Can't do that.
such as introducing a particular piece of legislation. I think that's what this is intended to address, not the fact that you're an attorney and generally vote for things that affect the courts.
Right. So there's a specificity to this, which goes beyond just simply your involvement in the profession and market. Yes. Oh, actually, we're going to call a recess here for
Okay, just one little statement. Mr. Lambert, thanks for clearing that up. But this is what they handed me when I first joined. And it says New Hampshire General Court Ethics Booklet. So maybe this isn't the one they should be handing out to all of us when we first get here.
No, it is, it's just that Section 6 is about staff. So Section 4 would be.
But as I say, so I didn't mean to, say something that was incorrect. And I apologize to the committee.
We're going to take a 10-minute recess. We will reconvene in 10 minutes.
I would like to make a motion that we do in fact go ahead and forward the information and discussion and, notes, all of the information we have acquired and discussed thus far, to the House Legal Counsel, so that we can be better instructed in what would be a good procedure or process to continue this in any direction that it could possibly go. And I'm sure, as we've discussed, there are a number of ones, and I'd like to speak to my motion.
Please do.
Yes, it seems,
Oh, can I have a second?
it seems as though in the course of our discussions, there are a number of points of contention, not in a contentious way, but just by nature of the discussion, just that there's the question of, are we just examining
our laws and our constitution, and are we separating, are we depersonalizing and separating, Representative Brunelle from the situation entirely? And that seems to be one issue. Secondly, it seems the other issue is, are we, as this committee who's been charged with seeing this through in some way, are we to be the determiners of, a hearing process, and if there is in fact a violation at hand, or are we just to clarify laws for the future, that type of thing? So I just think that since on those points alone we could debate and have debated or discussed for a while what would be the way forward, I think it would be best if we were to have some opinion from people that know our laws and process and precedent and whatnot, what would be possible next steps given what we've discussed so far. I think that's the most impartial and depersonalized way that we could go forward with this, with respect to ourselves, our charge, Representative Brunelle, who is in question here, and also the representative who brought this complaint before the entire House, and so we have to respect that fact as well.
We've already had sufficient debate on this, so we're gonna go to a vote.
Point of question.
Point of order?
Yes, please. We had someone who was ready to make a motion and he was shut down, and I understand why.
I didn't see this.
Representative Kerr was going to make a motion. Now, I really appreciate what you've said. What I like is that you get things so clear, and that's really helpful to my colleague, Representative Garcia. But I think I had the right name, I hope, but I want to hear Representative Kidder's motion first, please.
We have a motion on the floor, and actually we're
Well,
gonna vote on it.
but that was kind of forced on us, sir, with
Well,
respect.
we have a motion on the floor, so the clerk will call a vote. Please. We've already had the discussion, we now have a motion on the floor, we're gonna vote on it.
I do not believe that that is the case, Mr. Chairman.
Can't do that.
I believe the motion was made 30 seconds ago, and we have not discussed anything
Right.
about the motion.
The motion is a response to the discussion we've just had.
That's not how it
It'll
works.
last for an hour and 20 minutes.
That is Representative Garcia responding to the discussion we had and making a motion. We now have to discuss Representative Garcia's
Yes.
motion that she has made.
Yes.
If you wish to do that, that's fine, but we're gonna call a vote as soon as we're done. We'll go around, you can make your remarks, and we'll have a vote. Yes, Representative Wallner.
Well, I would like to know who exactly Representative Garcia means will review this. Are you talking about the House Counsel, or are you talking about bringing in legal constitutional experts that we know in New Hampshire are available to speak
House
to us?
counsel as discussed.
Just House Counsel.
All up?
What?
All up?
Well, my follow-up is that, when we started this several weeks ago, we talked about, the chairman talked about having legal constitutional experts come in and talk to us. We did have people come in and talk to us. I don't think any of them would be characterized as legal constitutional experts. And I guess I would like to see us at this point, and I wish we had done it maybe 4 or 5 weeks ago, bring in someone like a Chuck Douglas or Attorney Van Loan and Marcus Hearn, some people who can speak to this from a legal constitutional expert's knowledge. And I would like to, I feel like we're going backwards, but I would like to hear from some of them as well as the House Counsel.
Representative Johnson, let's see, Representative Johnson and then Representative Brown.
No, I'm free, I'm just listening, thank you, sir.
2 points. First, I was actually just a clarification. Is it a suggestion to refer this to House Counsel so House Counsel can lay out potential options for us, or is it to recommend it to House Counsel so that we can get a legal opinion on the matter?
No, I meant in their expertise as House counsel to the proceedings and laws surrounding the House, that they would give us our available options to go forward with, as a formal recommendation in terms of you could do this, or you could do that, and those are your options, that's all.
And then my second point was just going to be, echoing what Representative Wallner says, well, strictly from the point of, I'm not indicating that House Counsel will take a position one way or the other, but the House Counsel is appointed by the Speaker, am I correct?
That's
And
correct.
would thus technically be viewed as a Republican appointee to make this matter, and I think it would be very useful if we could get an independent third party to be the one to review this matter, because I'm not saying that he's going to take a political position on this one way or another, but referring this matter to a political appointee to give us a legal opinion does seem to cloud the process when we go outside and get a third independent counsel who's not associated with the process at all to perhaps make sure that the process is crystal clear.
Let's see, Representative Duarte.
I agree with Garcia's motion, but I feel, there's consequences with elections. I trust our speaker and I trust the House to do the right job. I don't think they're gonna come in and try to influence us. I think what we're gonna be looking for is guidance from him as to come to a better decision or conclusion by having the proper information at our disposal. So I don't feel we should go outside.
No further discussion. Clerk, call the roll.
Representative Comefo,
Yes.
Representative Gonzalez, which is myself, yes. Representative Kidder,
No.
Representative Garcia, Representative Tobin,
Yes.
Representative Ball,
Yes.
Representative Representative Bradley, Kevin Brown, Representative Condra,
Yes.
Representative Duarte,
Yes.
Representative Harvey is not here, Representative Richardson is not here, Representative Reader,
Yes.
Representative Brandon Brown,
No.
Representative Keynes,
No.
Representative Warner,
No.
Representative Chase,
No.
Representative Johnson,
No.
and Representative and Chair Mirski.
Yes.
Okay, the count is as follows. 9 yes, 6 nay.
I'd like to, I want to thank Representative Johnson. I apologize for being too quick on that. I just thought I called the vote too soon. That's what I mean. I think we've been in this for the last hour and 20 minutes, and we're just getting impatient, so. Well, I would like to, we have a work session scheduled for next Thursday. I don't know whether the council will get back to us by then or not. If you can't, then I suppose, since it's going to be in the calendar, we may open it and just recess it until when we can next get this material from him. In the meantime, I guess we'll wait for that material to come back to us, and then we'll move on.
I guess I'll go back to my, question before was, is there any possibility that we can get in, someone else to speak to this besides just the House Counsel?
I think it's a possibility. I wouldn't want to preclude it. I won't preclude anything. What we've been trying to do is do sort of what you're talking about. I'll tell you what. We called a variety of constitutional experts, just to give you some, repeat what I think we said here earlier. We called Jerry Danielle. We called Charlie Clark. We called a lot of individuals, and in fact, we got in touch with Marcus Hurd. Unfortunately, he got back. He told me by left message on my phone that he was unavailable on the Thursday the hearing was going to be held. And by the time he called me back, like the night before, I'd already made other arrangements. So it's not as if we haven't been out there trying to do this. And Mr. Wallace, who has an excellent reputation as well, is the person we ultimately settled on. So I wanted to make that clear. We were not trying to avoid having other people, and we did search for the best individual we could find. Oh, by the way, and Mr. Reed called him personally. We learned quite a bit about the New Hampshire Constitution, and he was unavailable as well. So it's not as if we hadn't attempted to do that. I wanted to make that clear. It's just that these individuals were either not available Mr. Danielle, for example, said he made it a point many years ago to never appear before legislative committees that had anything to do with constitutional questions. So that was what he told me. So the individual that came to speak to us, I tried to find the very best individual we could. And I think Mr. Lambert will validate that. We worked quite hard on it, and the individual we have to make it good. So I'm going to close this work session. I thank you all for coming. Stay tuned.
Do you have a copy of the
Thank you, Representative King.
Only he does.